Hi guys! Welcome to another episode of Attorney Javier's Law Lectures for Students, where we continue with our discussion on the Anti-Money Laundering Act of the Philippines as amended, or AMLA for short, and its implementing rules and regulations, or IRR. Now, in the last episode, I gave an overview of AMLA with special focus on the different acts which are punishable as money laundering offenses. One of the offenses discussed in the previous episode was that of failing to report covered or suspicious transactions to the Anti-Money Laundering Council, or AMLC. And I mentioned that this particular crime can only be committed by covered persons. So today, we will discuss who are these covered persons and what are their obligations under AMLA. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. A like on this or any of my other videos would also be greatly appreciated. Now let's begin. To review, AMLA and its amendments did not specifically define the term covered persons, but rather provided a growing list of persons covered by and subject to the provisions of AMLA. Despite the absence of an express definition, we can nevertheless define covered persons as those natural and juridical persons upon whom AMLA imposes various obligations to prevent money laundering. Now, due to the rapid evolution of the crime of money laundering, it is highly likely that future amendments to AMLA may further expand the list of covered persons, which is now actually very long, with at least 10 natural and juridical persons in general, and even more under their specific listings. Because the list of covered persons is very long, and due to the likelihood of future amendments adding to this list, I will not have enough time to enumerate and discuss each covered person in today's discussion. Nevertheless, I will give a few examples. And you can just read Section 3, Paragraph A of the law to learn more about the full list. For your convenience, I have compiled the latest amendments to AMLA as of 2023 in a single document and uploaded it on Scribd, which you can view and download for free, link in the description below. Now, as discussed in the previous episode, we can classify covered persons under 4 categories, namely, those under the supervision of the Bangko Sentral ng Pilipinas, or BSP, those under the Insurance Commission, those under the Securities and Exchange Commission, or SEC, and those covered persons who are designated non-financial businesses and professions, or DNFBPs. For those supervised by the BSP, we have banks, pawn shops, foreign exchange dealers, and other non-bank financial institutions subject to BSP regulation. Under the supervision of the Insurance Commission, we have insurance, reinsurance, and pre-need companies, agents, and brokers, among others. Under SEC supervision, covered persons here include securities dealers and brokers, investment houses, and other entities engaged in financial derivatives, cash substitutes, and other similar monetary instruments or properties. Finally, for the category of DNFBPs, we have jewelry dealers, casinos, and offshore gaming operators, real estate brokers, and developers. Take note that as a general rule, lawyers and accountants are excluded. They're not included from the list of covered persons in relation to information concerning their clients or where disclosure of information would compromise client confidences or the attorney-client relationship. In this regard, they are not required to comply with the obligations imposed by AMLA. But These lawyers, accountants, and other professionals will be considered covered persons, and therefore they have to comply with the obligations of AMLA if they provide any of the following services. First, managing client money, securities, or other assets. Second, managing bank, savings, securities, or other assets. Third, organization of contributions for the creation, operation, or management of companies. Or fourth, creation, operation, or management of juridical persons or arrangements, and buying and selling of business entities. Thus, if lawyers, accountants, or other professionals provide any of those services, they, together with all the other covered persons, must comply with the obligations set forth in AMLA, its amendments, and the IRR. Now, while AMLA and its IRR impose several obligations on covered persons, today's discussion will only focus on the three main ones, namely customer identification or due diligence, record keeping, and reporting of covered and suspicious transactions. The first obligation of covered persons in the prevention of money laundering is customer identification or due diligence. The IRR defines customer due diligence, or CDD for short, as the procedure of identifying and verifying the true identity of customers, their agents, and beneficial owners, including understanding and monitoring of their transactions and activities. Under this obligation, covered persons must establish and record the true identity of its clients based on official documents, maintain a system of verifying the true identity of their clients, and, in case of corporate clients, require a system of verifying their legal existence and organizational structure, as well as the authority and identification of all persons purporting to act on their behalf. Thus, CDD is conducted for the following purposes. First, to identify the customer, its agents, and beneficial owners, to determine the risk posed by each customer. Third, to establish, maintain, close, or terminate the account or business relationship. And fourth, to assess the level of monitoring to be applied. These purposes are reflected in the specific CDD measures required by the AMLA IRR to be conducted by covered persons. And these are sometimes generally referred to as the framework of KYC, or Know Your Customer, or Know Your Client. While KYC and CDD may sometimes be used interchangeably, KYC refers more to the process involving collecting and verifying customer information before starting a business relationship, while CDD encompasses the continuous process of collecting, verifying, updating, and evaluating the customer's information for use in assessing their risk profile for illegal financial transactions throughout the entire business relationship. Now, due to time constraints, I will not go over the CDD measures in detail. But briefly, some CDD measures required to be conducted under the AMLA IRR include: first, we have the CIP, or Customer Identification Process, or the duty to implement systems for collection and recording of proof of identity of first-time customers. We also have CVP, or Customer Verification Process, or implementing and maintaining a system of verifying the true identity of clients, including validating the truthfulness of the information and confirming the authenticity of the identification document submitted using reliable and independent information. We also have the IVA, or Identification and Verification of Agents, or simply confirming the identity of the agent and the fact that he is authorized to act on behalf of a customer. We also have BOV, or beneficial ownership verification, or simply identifying and taking reasonable measures to verify the beneficial owner of the account. And we also have determination of the purpose of the relationship. And we also have conducting an ongoing monitoring process on the basis of materiality and risk to ensure that the customer's accounts and transactions are consistent with what the covered person knows about its customer, their businesses and risk profile, and where necessary, the source of the funds. So, CDD requirements are not only applied to new customers, but also on existing relationships at appropriate times. In certain cases, additional CDD measures are required to be conducted. And again, I will only be giving a brief overview due to lack of time to discuss each in detail. So, in cases where a customer is identified to be a politically exposed person, or PEP, or an immediate family member or close relationship or associate of a PEP, and there is a higher risk business relationship, then reasonable measures must be taken to establish the customer's source of wealth or funds, and senior management approval is required before establishing or continuing the business relationship. In case of life insurance and other investment-related insurance policies, identification and verification of the identity of the beneficiary, determination of whether the beneficiary is a PEP, and the inclusion of the beneficiary as a relevant risk factor in determination which degree of diligence to apply are among the additional CDD measures that must be taken. Now, in case it is found that there is higher risk, senior management must be informed before the policy proceeds are paid out, so that the covered person can scrutinize the business relationship with the policyholder, and if necessary, to file the STR, which we'll talk about later. Other additional CDD measures are required to prevent correspondent banking activities, money, value, or wire transfer services, and new technologies from being used for money laundering or terrorism financing activities, including the adoption of policies and procedures, registration with the supervisory authority, and risk assessment, among others. Further, stricter CDD measures are required in certain instances. For instance, EDD, or enhanced due diligence, is required when covered persons deal with shell companies or with bearer share entities, and covered persons are prohibited from dealing with shell banks. EDD, or enhanced due diligence, is also required when dealing with accounts, transactions, and relationships from foreign jurisdictions or geographical locations with greater risks for money laundering, terrorism financing, or associated unlawful activities, or which have inadequate internationally accepted money laundering or counterterrorism financing standards. Now, covered persons are mandated to undertake these CDD measures in the following instances, namely when, first, establishing the business or professional relationship at the start. Second, when carrying out occasional transactions above 100,000 pesos or any other threshold set by the relevant supervising authority, including situations where the transaction is carried out in a single or several operations that appear to be linked. Third, when carrying out occasional wire transfers from non-customers for transactions exceeding the set threshold. Fourth, when there is a suspicion of money laundering or terrorism financing, regardless of any exemptions or thresholds. Or fifth, when the covered person has doubts about the veracity or adequacy of previously obtained identification information and or data. So in those instances, the covered person has to conduct CDD. Now, In conducting CDD measures, covered persons are required to undertake a risk-based approach. Specifically, they must assess which customers are likely to pose low, normal, or high risk in order for the covered person to know whether to apply enhanced, averaged, or reduced due diligence in examining the background and purpose of their customers' transactions to determine continuance or discontinuance of service or business relationship. The higher the risk, the higher degree of diligence. So in short, they will find out if this customer is high risk, low risk, normal risk, and then they will apply the appropriate degree of diligence, either EDD, ADD, or RDD, enhanced, average, or reduced due diligence, to determine if they will continue or terminate the relationship. Now, in case covered persons are unable to comply with the relevant CDD measures, they are mandated to first refuse to open an account, refuse to commence business relations, or refuse to perform the transaction, or they shall terminate the business relationship, and they will file an STR, or a suspicious transaction report, in relation to the customer if warranted by the circumstances. Now, however, in cases where covered persons form a suspicion of money laundering and other associated unlawful activities, and they reasonably believe that performing the CDD process will tip off the customer will suddenly be aware that they're under investigation or under the CDD measures, then the covered persons do not have to pursue the CDD process, but should instead file an STR, or a suspicious transaction report. They will also closely monitor the account and review the business relationship. This is to avoid tipping off the customer so they don't run away and hide the dirty money. Now, related also to CDD, covered persons are required to maintain their customers' accounts only in the true and full name of the account owner or holder. As such, the following accounts are expressly prohibited. These are the prohibited accounts. First, anonymous accounts. Second, accounts under fictitious names. And third, numbered accounts, meaning those accounts identified only by numbers except for non-checking numbered accounts. And all other similar accounts are prohibited. Now, we can move on to the second obligation of record keeping, which simply requires covered persons to maintain and safely store all customer records and transaction documents for 5 years from the date of transaction. For closed accounts, the records on customer identification, account files, and business correspondence are required to be preserved and safely stored for at least 5 years from the dates when the accounts were closed. And if a case has been filed in court involving a particular account, the obligation to retain and safely keep the records may last even beyond the 5-year period. It will last until the AMLC gives confirmation that the case has been resolved, decided, or terminated with finality. And failure to comply with the obligation to keep records is punished with a criminal penalty of 6 months to 1 year of imprisonment, or a fine of 100,000 pesos to 500,000 pesos, or both. The final obligation for discussion today involves the reportorial requirements. Specifically, AMLA as amended requires covered persons to file covered transaction reports, or CTRs, to the AMLC within 5 working days from the occurrence of those transactions, while the 2021 AMLC registration and reporting guidelines under Regulatory Issuance Number 4 Series of 2021 requires covered persons to file suspicious transaction reports, or STRs, within the next working day from the occurrence of such transaction. Thus, covered persons covered persons must be able to properly identify whether a certain transaction is either a covered or a suspicious transaction so that they can timely comply with the reporting requirements. Okay, so they have to file those CTRs or STRs within their respective deadlines. So how will a covered person know whether a transaction is covered or suspicious? The latest amendments to AMLA under RA 11521 define covered transactions to include the following. First, in general, any transaction in cash or other equivalent money instrument involving a total amount in excess of 500,000 pesos within one banking day. Okay, 500,000 pesos in excess of 500,000 pesos within one banking day. Second, for casinos, a single casino cash transaction in excess of 5 million pesos or its equivalent in any other currency. And the third covered transaction is for real estate developers and brokers, a single cash transaction in excess of 7,500,000 pesos or its equivalent in any other currency. On the other hand, suspicious transactions are transactions with covered persons regardless of the amounts involved. Okay, so you don't check the amounts anymore. You just check where any of the 7 following circumstances exist. Okay, so they are attendant to the transaction. First, there is no underlying legal or trade obligation, purpose, or economic justification. There's no ostensible reason why that money suddenly appeared. Second, the client is not properly identified. Third, the amount involved is not commensurate with the business or financial capacity of the client. It's weird that he's earning or receiving this much money. That's not what he usually earns. Fourth, taking into account all known circumstances, it may be perceived that the client's transaction is structured in order to avoid being the subject of reporting requirements under the AMLA. So they agree that, wait, I'll send you this amount first, and then next month this amount, and then next month this amount again. Okay, so that the AMLC won't find out. Okay, so if it looks like that, then it's also subject of an STR. Next, any circumstance relating to the transaction which is observed to deviate from the profile of the client and or the client's past transactions with the covered persons. So if the client usually interacts with the bank in this amount every month, then suddenly the amount is bigger, that's a suspicious transaction. Okay, it deviates from the client's profile. No? Sixth, the transaction is in any way related to an unlawful activity or offense under AMLA that is about to be, is being, or has been committed. Now, we talked about the unlawful activities in the last episode, no, which include kidnapping for ransom, illegal drugs, terrorism, murder, etc. And the last is the catch-all provision, any transaction that is similar or analogous to any of the foregoing. So in each of those cases, covered persons are obligated to submit CTRs or STRs as the case may be, and to review covered transaction reports must be filed with the AMLC within 5 working days from the occurrence of the transaction, while suspicious transaction reports must be filed with the AMLC within the next working day. In case the transaction is determined to be both a covered and a suspicious transaction, once the transaction breaches the 500,000 peso threshold and there are suspicious circumstances, the AMLA IRR directs the covered person to first file a CTR, then update the report once it is finally confirmed to be an STR. Again, the obligation to file these reports is mandatory, such that the failure of covered persons to file CTRs or STRs with the AMLC is punishable as a money laundering offense, though with a penalty lower than the other enumerated acts, specifically with imprisonment of 6 months to 4 years or a fine of 100,000 to 500,000 pesos, or both. Now, in making these reports, the covered persons will certainly have to include information which may identify the account holder and disclose certain details of the account. So, one might ask, does complying with the obligation to file these reports violate the Data Privacy Act, Bank Secrecy Law, or any other confidentiality laws so as to make the covered person, its officers, or employees liable? The answer to both questions is no. Why? AMLA does not violate any privacy rights nor confidentiality laws because AMLA expressly serves as an exception to those laws, as provided in paragraph C of the amended Section 9, which states that when reporting covered or suspicious transactions to the AMLC, covered institutions and their officers and employees shall not be deemed to have violated the following laws. First, RA 1405 or the Secrecy of Bank Deposits Law as amended. Second, RA 6426 or the Foreign Currency Deposit Act as amended. Third, RA 8791 or the General Banking Law and other similar laws. Moreover, RA 10173 or the Data Privacy Act in its Section 4, Paragraph F, explicitly states that the Data Privacy Act is inapplicable to AMLA and its amendments. Now, since the filing of covered and suspicious transaction reports with the AMLC is expressly made an exception to confidentiality laws, there is no violation in case of reporting. And the covered person, its officers, and employees cannot be held liable for the mere fact that they filed a CTR or STR as the case may be. In fact, AMLA even affords protection to the covered persons, its officers, and employees to help encourage and ensure the filing of these CTRs and STRs through what is known as the Safe Harbor Provision. Under this provision, as long as the person filing the CTR or STR has acted in the regular performance of his duties and has acted in good faith, then no administrative, criminal, or civil case can be filed against them, whether or not such reporting results in any criminal prosecution under the AMLA or any other Philippine law. So, covered persons and their officers or employees should not be afraid to file CTRs or STRs because they are protected in that a case cannot be filed against them as long as they were acting in the regular performance of their duties and in good faith. This requirement of good faith is important because the law, of course, should not be abused, such as when reports, whether true, false, or fraudulent, are filed to harass, intimidate, or blackmail a customer or account holder. To prevent such abuse or to prevent bad faith, in fact, the AMLA punishes the malicious filing of covered or suspicious transaction reports with imprisonment of 6 months to 4 years or a fine of 100,000 to 500,000 pesos or both. Moreover, even though AMLA protects covered persons and their officers or employees from prosecution for violation of confidentiality laws, this does not mean that they are given unbridled freedom to do whatever they want with the information that they have. Okay? Because AMLA explicitly imposes the obligation on the covered person and its officers and employees to keep these reports and their contents confidential. Now, this is the duty of confidentiality. Specifically, covered persons, their officers, and employees are prohibited from directly or indirectly communicating in any manner or by any means to any person or entity, especially the media, the following information. First, the fact that a covered or suspicious transaction report has been filed or is about to be filed. Second, the contents of that report. Or third, any other information in relation to those CTRs or STRs. AMLA further prohibits the reports from being published or aired in any manner or form by mass media, electronic mail, or other similar devices such that In case these prohibitions are violated, the responsible officer or employee of the covered person and media shall be held criminally liable with imprisonment of 3 to 8 years and a fine of 500,000 to 1 million pesos. In this case, the word used is "and". So those are the three main obligations imposed by AMLA on covered persons. Again, customer identification or due diligence, record keeping, and reporting of covered and suspicious transactions. However, these are not the only obligations and preventive measures that must be complied with by covered persons, as there are others set forth in AMLA and its IRRs. Unfortunately, for lack of time, and since this is only an overview, I will not be discussing those obligations in detail here. Nevertheless, here are some other obligations imposed on covered persons, namely that of registering with AMLC's electronic reporting system for the purpose of complying with the reporting requirement, because that's where they'll file those CTRs and STRs, in the AMLC's electronic reporting system. Also, the obligation of conducting institutional risk assessments, internal audits, also undergoing risk management. This one is also important, developing a money laundering and terrorism financing prevention program or MTPP, designation of a compliance officer, establishment of screening procedures to ensure high standards when hiring employees, continuing education and training, and other obligations. So that's it for an overview of who are covered persons and what are their obligations under the Anti-Money Laundering Act of the Philippines as amended, together with its implementing rules and regulations. And I will continue the discussion on AMLA in the following episode, specifically on the legal remedies under AMLA. So if you would like to know when it is available, please like, share, and subscribe. So I hope you may have learned a thing or two, and I hope to see you next time. See you soon. Bye.